Adoption establishes a legal connection between a child to an individual or individuals, essentially replacing the biological parents. There are two types of adoption. Adoption can be organized either through a state licensed agency or through a private or independent company. In an agency adoption, a state licensed agency arranges for the adoption of children who have either been voluntarily surrendered by their parents or whose parents have had their rights terminated. These children are typically placed in a potential adoptive foster home while awaiting adoption. Relinquishment or adoption counseling is generally available to parents in both situations in order to help explain the legal consequences of severing the parent-child relationship. A home study is then completed for the adoptive parents, which usually includes a background check and home inspection to look for any safety concerns. All states recognize agency adoptions, and because they are licensed by the state, must adhere to specific regulations. In contrast to agency adoptions, some states also allow for private or independent adoptions. Private adoptions generally concern infant children, so arrangements are usually made during the mother's pregnancy. Children are placed directly with the adoptive home in this process. Parents relinquishing their rights are not provided with counseling regarding their decision. Unlike agency adoptions, private adoptions may involve adoptive parents providing financial support to the biological parents. Because of the lack of counseling as well as the possible financial motivation for relinquishing parental rights, some states have prohibited private adoptions altogether. What happens if a parent changes their mind about relinquishment? In most cases, private adoptions allow for a revocation period, whereas agency adoptions are usually irrevocable. Most states have enacted safe haven laws to address the issue of children, usually newborns, being abandoned shortly after birth. Within 72 hours to 30 days of a child's birth, a parent can take an infant to a fire station, hospital, or other designated location. In some states, the parent does not have to leave any identifying information. Parents are typically immune from prosecution for abuse and neglect. However, some states only allow the use of a safe haven law to be a defense against criminal charges. When children are left under the safe haven laws, there is no requirement that both parents consent to the relinquishment. In fact, the other parent may not even know that the other has taken advantage of the safe haven provision until it is too late. Once the parental rights of both parents have been terminated or relinquished, the child is then legally free to be adopted. In an agency adoption, the adoptive parent and the adoptive home must be approved prior to the adoption of the child. Some states require that children be placed with their potential adoptive homes for a specific period of time, usually 6 months, before the adoption can be finalized. After the adoptive home has been approved, a court must finalize the adoption, approving the legal relationship between the adoptive parents and the child. An adoption severs all ties with the biological parents, but it also severs ties with family members. Recognizing that sometimes these connections may be beneficial, some states allow for open adoptions. Open adoptions allow continued communication, which may include visitation, with the biological family. Although more common in private adoptions, open adoption provisions are allowed in agency adoptions in certain states. Biological parents do not always wish to continue contact with their children once they have been adopted. A parent can choose to have their information sealed so that a child, upon reaching the age of majority, is not able to locate their biological parents. Some states require that adopted individuals obtain a court order to access their adoption records. All families are different, and the structure of adopted families can have an effect on the adoption process. Single parents who wish to adopt may find that adoption agencies prefer to place children in two-parent households. Gay and lesbian individuals have also faced challenges as many states prohibit them from adopting and being foster parents. Similarly, co-parent adoptions have become more common. These occur when only one partner in a same-sex relationship is recognized as the legal parent of a child. Co-parents, therefore, have no visitation or custody rights should the relationship end. Step-parent adoptions occur when the stepfather or stepmother wishes to formalize the relationship with a stepchild. As in other adoptions, the non-custodial parent must consent to the adoption or it will not be granted. Unlike other adoptions, the biological parent often does not relinquish his or her rights to the child. Some states require that parents be married for at least 1 year prior to petitioning the court for a step-parent adoption. If a couple seeks to adopt a child that is not related to either of them, it is considered a joint adoption. Transracial adoptions, where the parents and child are not the same race, have greatly increased since a federal statute made it illegal for an agency to deny or delay an adoption based on the race of the parties. Finally, unlike single mothers, single fathers do not necessarily need to consent to the adoption of their children. The Biology Plus approach discussed in Week 5 is also used in connection with adoption consent. Merely being a father biologically does not vest parental rights. Instead, a father must also form a relationship with his child. For the most part, an adoptive family cannot abrogate or undo the adoption once it is final. If there are extraordinary circumstances unknown to the parent at the time of the adoption, such as a child who requires institutional care for the rest of their life, then some states allow the adoption to be reversed. Abrogation may also be allowed if an agency used fraud or misrepresentation in presenting the child to the adoptive parents. Adoptive parents may not always be able to abrogate the adoption, however. Some states allow them to sue the agency for wrongful adoption. Damages are generally limited to the recovery of unexpected expenses, such as medical care or the cost of specialized treatment.